Thank you, Rebecca.
Right, thanks for that introduction and for setting up the scene for us. So now that our members of the audience have become acquainted with what an IT dispute might involve, the particular nature of IT disputes, we're going to look at arbitration as a form of dispute settlement for these kinds of disputes. We're going first. I'll give you a brief overview of what arbitration is, and then we'll also discuss why it's especially attuned to resolving disputes in the IT field, why it's an appropriate dispute resolution procedure. So you've probably heard the term ADR in the past. That's shorthand for alternative dispute resolution, and arbitration is under this umbrella of dispute resolution procedures. I just want to bring to your attention that arbitration isn't the only form of ADR. There's also mediation and conciliation. However, the dispute resolution form that's often indicated in contracts is arbitration. Also, I want to bring to your attention that ADR is increasingly being called appropriate dispute resolution. It was called alternative dispute resolution in the past because it was seen as an alternative to court litigation. But now, since more and more contracts specify arbitration as a first resort, ADR and that general and that umbrella of dispute resolution procedures under it is the term nowadays it's appropriate dispute resolution. However, in our laws, particularly the 2004 ADR Act, Philippine law still uses the term alternative dispute resolution. So what is arbitration? Some of you may be familiar with it. Some of you might not have any idea. So I'll set up a definition for you. So arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. So there's lots of elements to that definition. We'll get down in a little bit. So it's a private dispute resolution procedure, and by private that means it's an alternative litigation in court. Courts are of course part of the judiciary, a branch of government. Arbitrations, while there are some government arbitral institutions, arbitrations are generally run by private institutions or convened on an ad hoc basis. That means not necessarily affiliated with a particular arbitral institution, but organized, and then private individuals are appointed to be arbitrators. Now, an important thing, since we're looking at, for the first part of this webinar, we're looking at government contracts in particular. I want to bring to your attention that the Government Procurement Reform Act, or Republic Act 9184, specifically requires arbitration as a dispute resolution procedure. So Section 59 of this law specifies that government contracts should include a dispute resolution clause that refers any disputes to arbitration. So I'm trying to go to my next slide. So now that you know what arbitration is, generally, let's look at some key features and advantages of arbitration. So you'll note from the definition that it's a dispute submitted by agreement of the parties, and this speaks to the core element of arbitration, which is consent. Arbitration is based on the consent of the parties. That means that they have agreed to submit the dispute to arbitration, and this can happen. This can happen in two ways. So we already mentioned that government contracts require an arbitration clause that refers any potential disputes. That means even before a dispute has arisen, at the point that the contract is being formed, being signed, parties have already agreed that if any dispute arises with respect to the contract, they are going to use arbitration as a dispute settlement procedure for that contract. That's agreeing to submit to arbitration before a dispute has even arisen. It's also possible in some contracts, so that's a requirement in government contracts. There are some contracts that, so for example, contracts between private parties where they did not provide for arbitration. But if when a dispute arises, they think that it's better to go to arbitration rather than a court, they can submit, they can at that point, after a dispute has already arisen, can agree to submit that dispute to arbitration. So that's called a submission agreement. So you have your arbitration clause as part of the contract, or a dispute resolution clause as part of the contract. That happens before a dispute even happens, even before the project is embarked. And then you have the potential to make a submission agreement. So this is a subsequent agreement between the parties to submit the dispute to arbitration, just in case the contract did not contain an arbitration clause. Now, an arbitration clause in a contract, it is a contractual provision, so it is binding on the parties. So just like all contractual provisions which must be respected, an agreement in a dispute resolution clause in the contract to submit to an arbitration makes it mandatory for the parties to submit that to arbitration. If one party decides to go to court, the court will, under Philippine law, refer them to arbitration because an arbitration clause exists in that contract. Now, the second key feature is that parties can choose the people who will decide the dispute. The disputing parties can appoint arbitrators. They essentially choose who would be the best people to decide their dispute for them. Now, an arbitration can be decided by a sole arbitrator, meaning there's just one arbitrator, and that means the parties agree who that arbitrator will be, or if they're submitting the dispute to an arbitral institution, perhaps that institution has procedures for appointing that sole arbitrator. Typically, just as often, or perhaps slightly more often, a dispute will be decided by an arbitral tribunal composed of 3 members. And in that instance, the typical appointment procedure is that when a claim is submitted, the claimant already nominates an arbitrator, and then when the respondent responds to that claim for arbitration, they likewise nominate an arbitrator. So each party gets to choose who their arbitrator will be. And then, depending on the procedure they've agreed upon, or depending on the procedure of the arbitral institution to which they've submitted their dispute, the president of the tribunal will be decided either by the agreement of the parties, or by agreement of the 2 appointed arbitrators, or by appointment of the arbitral institution itself. So so the procedures vary depending on the agreement of the parties and depending on the arbitral institution that's handling the dispute. And we will get to, we will take a closer look at why it's ideal for parties to choose their arbitrators in just a bit. However, I do want to highlight at this point that just because parties can choose who their arbitrators will be, that doesn't mean that those arbitrators are advocating on their behalf. No, arbitrators must still be impartial. While they are not judges, they should still maintain that impartial nature of a judge in deciding the dispute. The parties just nominate them because they think that that is the appropriate person with the appropriate expertise to decide their dispute. But that person is not an advocate. They are an independent decision maker on the dispute. Also, another key feature is that proceedings are confidential. You know that court procedures are, by their nature, public. And when it comes to IT contracts, there are certain aspects that parties will want to keep confidential: trade secrets, procedures, processes, perhaps just maintaining standing in the business community, not letting everyone know that there's a dispute with one of their projects. There are many reasons that people will want to keep the proceedings confidential, and arbitration provides that option because while the proceedings are going on, it isn't publicized, not like a court procedure where, as a general rule, the public can enter a courtroom and observe the proceedings. In arbitrations, the hearings are set, parties can choose the venue, they can decide who, the venue for hearings, decide who to allow into those hearings, and they have control about who has access to documents. Generally, arbitration is faster than court litigation, and that's one of the advantages that arbitration has over court litigation. IT disputes, by nature, information technology develops at a very fast pace and evolves so rapidly that if you're bogged down by a dispute, and then there will be, if there's a possibility for performance later on, the delay in resolving the dispute might affect the terms of the original IT contract to begin with. So when it comes to IT disputes, you want a rapid means of resolving the dispute, and arbitration offers a faster alternative to court litigation. Because when you convene an arbitral tribunal, the parties have considerable control over the calendar. They've essentially appointed people who are devoted to hearing their dispute, and depending on how busy those arbitrators are, things can move very fast and the dispute can be resolved fairly quickly. Also, arbitration provides a neutral forum for dispute resolution. When we think of government contracts in particular, there might be whether it's a fair or unfair perception that bringing it to court, which is a public institution itself, whether that gives the government an unfair advantage. This is, of course, courts are impartial and they should decide the dispute fairly, but it's that mere perception that bringing a government contract to a government institution for decision might give undue advantage to the government party in a government contract. So to avoid this unfair perception, arbitration offers that neutral forum for which to resolve the dispute, and parties feel more in control of this forum because they get to decide who will decide, and it's by electing their decision makers, the parties feel they have a fighting chance with respect to the dispute. Also, it is a binding procedure that results in a decision that can be enforced against the party. Now, the key word here of binding, this differentiates it from other forms of ADR, such as mediation. Mediation essentially gets the parties to sit down and discuss their dispute, likewise with conciliation. And these procedures do not necessarily come out with a binding procedure. Arbitration, in contrast with these other forms of ADR, results in a binding procedure that results in a binding decision that can be enforced against the losing party. Also, with respect to enforcement, just like enforcing a court procedure, you're going to look at enforcing the arbitral award where it will be beneficial for the winning party, and that is where the losing party has assets. So arbitration, whether it's a domestic arbitration or an international arbitration, the arbitral awards that result from enforcement can be enforced in theory anywhere in the world. But if it's most likely, if you have clients dealing with projects in the Philippines, you're probably going to want to enforce in the Philippines if there are assets to enforce against. But the great thing about arbitration is the portability of the decisions rendered in arbitrations. We have a treaty, one of the most well-subscribed treaties in the world, called the New York Convention on the Recognition and Enforcement of Arbitral Awards. This treaty is from 1958, and most countries in the world are parties to this treaty. So it's one of those rare treaties that most countries in the world agree on. And the Philippines is a party to this treaty. And what this treaty does is, if you want to enforce your award in another country, which is also a party to the New York Convention, that treaty makes it easier to enforce, because courts will have very minimal interference with the content of the award and seeking to enforce it. So now let's look at the types of arbitration that we're going to briefly look at today. So you have domestic commercial arbitration and international commercial arbitration. So these would be based on contract. So earlier we were discussing arbitration clauses. And so when in commercial arbitration, whether domestic or international, resort to arbitration is usually done through the arbitration clause that we discussed earlier, or the submission clause, which we all discussed earlier. The key difference between domestic and international is defined by law. The key difference is either one, the nationality of the parties, or two, the seat of the arbitration. The seat of the arbitration is where the parties have designated to be the place of arbitration. That doesn't necessarily mean that hearings will be held there. The seat of arbitration is important because it determines the law of the arbitration, or the lex arbitri, to be followed in the arbitration, which is different from the law of the contract itself. It could be the same law, might be different. So when choosing a seat of arbitration, if it's in a different country than if it's in a different country from where the parties are situated, that instantly makes it international. Under the definition, so the arbitration law of the Philippines, the 2004 ADR Act, incorporates by reference the UNCITRAL model law on international commercial arbitration. So UNCITRAL is a UN body that comes out with model statutes, and one of the model statutes that has come out with is the UNCITRAL model on international commercial arbitration. It's referred to in an annex of the ADR Act of 2004. So this text from 1985 is incorporated by reference. There is a newer version of this UNCITRAL model law from 2006. However, what the Philippine law incorporates by reference is the 1985 version. And by reference to this law, which was adopted as an annex in whole, so this entire text forms part of Philippine law by reference. The definitions of international and commercial are provided in Article 1 here. So the definitions of what's international is, as I've already mentioned, if the seat is in a different place from where the parties are, or if if the parties are from different countries. That doesn't mean, so note that you could have an international commercial arbitration in the Philippines if one of those elements are met. Domestic commercial arbitration means that the parties are from the same country, or in the case, so in the Philippines, they're both from the Philippines, their place of business in the Philippines, and then the arbitration is going to be conducted in the Philippines. I bring your attention again to the Section 59 of the Government Procurement Reform Act, which specifies that disputes shall be submitted to arbitration in the Philippines. So by definition, the law makes reference to Republic Act number 876, which is the Domestic Arbitration Act. But the arbitration law, the 2004 ADR Act defines international commercial arbitration in accordance with the UNCITRAL model law. So there's a bit of a disjoint if you're considering a government contract, which requires arbitration in the Philippines, and if one of the parties is a foreign supplier, for example. So under the UNCITRAL model law, that would be an international commercial arbitration, and that has some effect on the rules. So in 2009, the Supreme Court came out with rules on alternative dispute resolution. They have slightly different rules of how and when courts can assist with respect to these arbitrations. And I also want to bring into your consciousness investment treaty arbitration. So this is my specialization. Investment treaty arbitration involves, so this is, whereas the first two types of arbitration mentioned in this slide are contract-based. Investment treaty arbitration is based on treaty. So treaties are, of course, agreements between countries. So when you think of contracts as agreements between individuals or corporations, think of it, investment treaties are agreements between countries. Now, how does this impact potential dispute? treaties incorporate a mechanism called investor-state dispute settlement, which allows a foreign investor to directly sue a state, which if that foreign investor's country has an investment treaty with the Philippines, for example, and their investment in the Philippines, if their investment project needs an investment under that treaty, they could, and it was a government contract, then it might be possible for that foreign party to sue based on an investment treaty, to bring an arbitration based on a breach of a treaty rather than the breach of a contract. They could actually bring both. They are not mutually exclusive. I just want to bring into your consciousness that investment treaty arbitration exists. And it's particularly relevant if your client is a foreign company. So I could talk about investment treaty arbitration all day, but we don't have time for that. I just want to bring this concept into your consciousness. And I'm trying to go to the next slide. Okay. So now that we've looked at what arbitration is and what its key features are, let's examine why arbitrate IT disputes. So arbitration is an ideal form of dispute resolution for IT disputes. I'd like to highlight these three reasons, which we briefly touched upon earlier when we were looking at key features. So first is the expertise of the decision makers. IT contracts, by their nature, are very technical in nature, requires familiarity with the kinds of processes or deliverables involved in these IT contracts, and not everyone has that expertise. And certainly, if you have a dispute in this area, you want the decision maker for your dispute to be able to understand what that IT contract involves, what the technology involves, or what is expected of the technology, what were the deliverables, and was it met? So you want, because you're allowed to appoint your decision makers in arbitration, the expertise, you can choose arbitrators who have the necessary expertise to decide the dispute. And also, another advantage of having having decision makers who have sufficient or even expert knowledge in the field is that they can become more proactive when examining evidence. When an arbitrator is well acquainted with the type of technology involved or the types of deliverables in that IT contract, when an arbitrator is knowledgeable about a dispute, they can be more than merely passive listeners to evidence being presented. They can be proactive in asking questions about the evidence being presented or the testimony being presented. When your decision maker has expertise, it allows that decision maker to go beyond what's being presented by the party and ask the deeper questions. And this is definitely allowed in arbitration, not like perhaps it's more expected in arbitration, I would say, than in regular court procedures, where the judge will typically listen to the evidence presented, ask a question now and then. But when in an arbitration involving a highly technical dispute, you can have an active arbitral panel asking their own questions aside from the questions proposed by opposing counsel. And again, we've touched upon the confidentiality of the dispute resolution process. If the technology involved if the processes involved in the IT dispute are trade secrets, confidentiality is important for the client in these matters. So arbitration presents that a confidential forum to hear the dispute, which is different from the public nature of courts, as we've already discussed. And as we've discussed, IT disputes, so information technology by its nature, rapidly evolving, You want those resolutions, you want those disputes resolved quickly. So I'm trying to go to the next. So how does a dispute reach arbitration? You know what arbitration is, you know its advantages, you know its features. How do you even get there? So we've already mentioned the arbitration clause and in the contract itself, or the submission clause after the dispute has arisen. So contract-based arbitration, so you have that arbitration clause, or you have before the dispute even comes about, or you have the submission clause, and that is how you bring a dispute to commercial arbitration. Essentially, a party can invoke the arbitration clause and initiate a claim by submitting a request for arbitration and serving the other party with that request based on the arbitration clause. Or if they don't have an arbitration clause, they can agree to submit it to arbitration. That's how to initiate a contract-based arbitration. So for treaty-based arbitration, as I briefly just introduced you to a while ago, treaty-based, so instead of a contract, investment arbitration is initiated by filing a request for arbitration invoking the relevant clause or key breach, the breach in the treaty that the clause in the treaty that's breached by the government party. So in treaty-based arbitration, when invoking the treaty, the government is always the respondent here, and the foreign investor is the one initiating the claim. In contract-based arbitration, it could be either of the parties. Any of the parties who feels like they're not, the terms of the contract are not being met, there's a breach of contract, they can initiate arbitration. So let's take a closer look at how contract-based arbitrations are initiated. And for that, we're going to look at arbitration clauses. So I'm going to my slide on arbitration clauses. So as I've mentioned earlier, the inclusion of arbitration clauses in the contract is mandated by Section 59 of the Government Procurement Reform Act. And here I've provided for you a sample arbitration clause. Let's take some time to read it together. This is a sample with the basic elements in there. So a sample arbitration clause might look like this. Any dispute, controversy, or claim arising under, out of, or relating to the contract and any subsequent amendments of this contract shall be referred to and finally determined by arbitration in accordance with, and then our parties can choose the arbitration rules that they want to use. In ad hoc arbitration, that's not that is not linked to any specific arbitral institution. The usual choice is the UNCITRAL arbitration rule. Most arbitration institutions have their own rules, in which case parties can specify that. The arbitral tribunal shall consist of, and then parties can decide beforehand, do they want one arbitrator or do they want 3 arbitrators to decide their dispute? And then the place of arbitration shall be, and again, as I mentioned earlier, determining the place or seat of arbitration determines the law governing the arbitration, which has effects on enforcement and setting aside the arbitral award in the future. The language to be used in arbitral proceedings, if parties in different countries, they can choose to specify English or both their languages or another language. And the dispute, controversy, or claim shall be decided in accordance with the law of. So that's a substantive law. So you have the seat of arbitration, which determines the law of arbitration, and then you have the substantive law, which is the contract. So breaking down that sample arbitration clause, you have your basic elements. So we saw the basic elements reflected in that sample arbitration clause. You have the number of arbitrators and whether to choose 1 or 3. So it always has to be an odd number. You could even go up to 5, but that would be costly, time-consuming, and unnecessary. So typically, arbitral tribunals are composed of one arbitrator or three arbitrators. You want an odd number so that there's no tie. So in determining whether you want one or three arbitrators, parties should weigh the considerations of cost and efficiency against the value and complexity of the dispute. So the more, if it's a contract that costs a considerable number of millions of pesos and it's very complex, you'd probably want to go with three arbitrators rather than a sole arbitrator. So depending on the complexity of the dispute and the cost of the dispute will determine your decision whether to go with one or three arbitrators. In the place of arbitration. So this determines the law that relates the procedural framework. So for example, the availability of interim measures of protection. So if the seat is in the Philippines, so courts can participate in a limited way in arbitral tribunals, and this is provided for in the 2009 Special Rules of Court Alternative Dispute Resolution. It also determines, the place of arbitration determines the nationality of the award, and that is relevant when it comes to enforcement. And however, regardless of the place of arbitration, parties may hold meetings or hearings anywhere in the world. So even if, for example, parties choose the seat of arbitration in Singapore, but it's more convenient for them to have their hearings in Makati, that is perfectly fine. And then you have the substantive law, which is the law under which the arbitral tribunal decides the dispute. Arbitration clauses can be expanded further if the parties wish. One of the great things about arbitration is the flexibility of the parties. So parties can actually design an arbitration clause that provides more than just the basics. So there could be an appointment procedure. So the typical procedure is each party gets to nominate an arbitrator, but then parties can also specify in advance how the president of the tribunal will be appointed. Will the parties agree to the president, or will the appointed arbitrators agree on the president, or will the arbitral institution decide president of the tribunal should be? Other additional provisos in that dispute resolution clause might be the qualifications of the arbitrator. So this is something to consider if you are advising clients in an IT dispute. Depending on the complexity of your IT project, you might have some minimum qualifications for the arbitrators. Now, going back to the types of arbitration, of course, I just wanted to bring to your attention the types of arbitration that were relevant to IT disputes. So you have your commercial arbitration, whether international or domestic. You have some treaty arbitration. Of course, there are other types of arbitration. I'm sure you've heard of some of them, such as construction arbitration or labor arbitration. So not particularly relevant to our discussion today. I just want to bring your attention that there are many types of arbitration. And I just wanted to mention this, for example, qualifications of arbitrators. For example, in the Construction Industry Arbitration Commission, which deals with construction disputes, not all arbitrators there are lawyers. Some are engineers, because some contracts might specify that one of the arbitrators has to be an engineer in order to be able to understand the construction dispute. And we can see how that would be relevant for IT disputes in particular. So is the IT project of such a complex nature that perhaps it would be useful that a software engineer is one of the arbitrators has to be a software engineer? Would that be helpful? Arbitrators are not necessarily lawyers. Most of the time they are, but arbitrators are not necessarily lawyers. It's really up to the parties to decide who is the appropriate person and what kind of expertise that person has inside the dispute. Parties can also specify in their contract dispute resolution clause the time period for the delivery of the final award, essentially giving time limits how long the dispute can run, and also provisions for appeal. Of course, in the Philippines, appeal is governed by law. There are certain, there is some avenue for appeal with respect to arbitrations, even if it isn't binding. And so my last slide takes a closer look at treaty-based arbitration. So as I mentioned, this is another option that can be explored by a foreign or international supplier in an IT contract. It would depend, however, on their nature of activities in the Philippines. So to resort to investment treaty arbitration, um, the nature of activities of the foreign client does have to meet the standards of investment as defined under that relevant treaty. Also, whether this is a possibility depends on whether the country of origin of the foreign supplier has an investment treaty with the Philippines. So again, treaties are agreements between countries. This is not, we're not talking about agreements between individuals or corporations here. Treaties are agreements between countries, and these particular types of investment treaties provides a mechanism by which a private party can sue a government directly. So in contrast with contract-based arbitration or commercial arbitration, a treaty-based arbitration does not rely on the dispute resolution clause of the contract. So the restrictions in the contract of where that dispute can be brought, those are not relevant if one is considering the avenue of treaty-based arbitration. This is an entirely different avenue that can be considered in the case of a foreign client that qualifies as a foreign investor. So that is your look at arbitration in general, types of arbitration, and how it's attuned as a dispute resolution measure for IT contracts, and in particular, the requirements under the Government Procurement Reform Act for requiring arbitration as a dispute resolution measure. So I hope you found that helpful. Janice has some interesting points about arbitration in Singapore, and move on to her. Thanks for listening.
All right.